You talked about the prefatory language of the Second Amendment and the arguments over that. What other amendments have prefatory languages, and what meanings have those prefatory? What meanings have the prefatory language and other amendments been given?
Okay. The Second Amendment is the only amendment that has a preamble to it, but it's not the only part of the Constitution that has a preamble. There are two other preambles in the Constitution. There's, of course, the general language, we the people. We all know that. It's nice. It has no impact. People have tried to litigate it before. The courts have said no. This doesn't actually bind Congress. And then, of course, litigated more recently is the preambular language in Article 1, Section 8, which gives Congress the power to promote the progress of science and the useful arts by establishing a system of intellectual property protection. There has been litigation recently in the court. The Supreme Court looked at it last time in 2003, a case called Eldred v. Ashcroft, to see whether or not this imposed a sort of a meaningful limitation on Congress. That is, can Congress pass any copyright law it wants, or only those laws which promote the progress of science and the useful arts? And that did not get very far at all. It's interesting, at the time, though, as the court notes, when the Second Amendment was written, preambular language in constitutional provisions was actually quite common. Gene Volokh has a whole law review article about it, which was cited. And, of course, it was also the case in various statutes. This is my favorite example. This is from the Northwest Ordinance, which was enacted by the first Congress. It was a Confederation Congress law, of course, that was reenacted by the first Congress. The same Congress that passed the Second Amendment. And here's how a part of the Northwest Ordinance of 1787 starts. Religion, morality, and knowledge being necessary to good government and the happiness of mankind, schools and the means of education shall forever be encouraged. Well, that doesn't mean that if religion, morality, or knowledge were one day found to be unnecessary for good government, that we shouldn't have public schools in the states of the former Northwest Territory, of which I believe this might be one. So, again, we have many examples of such language being used, and the same exact syntax doesn't have any sort of practical meaning. Yes.
Where do you see, sorry about that.
Sorry, I was looking.
You know, Hellar seemed to be a lot about the keep part of the two-part. Where do you see the bear going as far as existing case law that defines parameters for that and what challenges may be in the offing?
Well, that's a great question. Of course, this was a keep case, not a bear case. There's a reason for that. Historically, courts have always given much greater protection to individual rights within the context of one's home. Even obscenity, which is unprotected in other contexts, the Supreme Court has held, is protected inside the home, and we just wanted to get the individual right done, and so we focused on keeping in the home. Bear, however, is also protected, and the court's opinion made quite clear that bearing means to carry, and while you can't carry maybe everywhere, you can certainly carry in some places, and while you can't carry everything, you can carry something, and while you can't carry in any manner you want, you can carry in some manner. The precedent on this is actually interesting. The 19th century saw a number of cases about the carrying of firearms, both under the Second Amendment as well as under various state right to keep and bear arms provisions. And the general rule in the 19th century came out pretty much like this. The government could ban you from carrying a concealed weapon because that was considered to be something that only dastardly assassins and sneaky people would do. You know, if you were a manly man, you would have your weapon out openly. That was the fashion of the day. I think that, and we've seen the Supreme Court actually endorse that in an 1890s case, Robinson, and I believe even the Hellar opinion has some reference to it. I think modern times we've seen sort of a reversal of this trend. Today, in most of the United States, virtually all the states allow fairly easily concealed carrying of firearms. Usually there's a licensing requirement. You have to meet certain objective standards. But if you meet those objective standards, typically some form of training, demonstrated competence, knowledge of use of force laws, you will get the permit. And what we've seen is that the population of permit holders is more law-abiding than police officers. We don't have a problem with people who have concealed carry permits committing crimes. It just does not occur. It's very, very rare when it does. And so we sort of have a happy acceptance of that, but open carrying of firearms is often considered to be, by some states, hostile, intimidating, unfriendly. Some people get freaked out by that. And so we do have states like Texas, for example, which is traditionally a very pro-gun state. You can have your concealed carry permit, but don't carry it openly. A reversal of the 19th century trend. My own belief is eventually what we're going to see is the courts saying to the states, you can regulate the manner of carrying, you can prohibit either open or concealed if you'd like, but not both. And you can license it, and I think that the typical concealed carry type law that we have in the United States, in most of the United States, will be found to be constitutional. That is, the state can require you to get a background check, to show some competence, and then they have to give you the permit because it is a right. I think that's a medium, it's a happy medium that most people in the United States would be happy with because it's worked out real well.
As somebody who's watched this case from beginning to end, impeccable job by you and your cohorts. Great. The court touched on the shall issue stuff for the licenses. Do you think that will affect the states that have currently may issue licenses for concealed carry or not because it's simply concealed carry where open carry is not regulated?
It's interesting. It depends on the state. I mean, if you have a state where it's may issue, but it's applied fairly loosely, I don't think that could be easily challenged because the courts will tell you, well, in an as-applied challenge, no one has a real problem. States where they have a may issue law, and may issue means you need to make a donation to the sheriff's reelection campaign or you need to win an Academy Award, those states are going to have a problem, particularly if they don't allow for the other form of carrying. So I really believe that in the end of the day, we're going to see, if we have incorporation, we will see states basically licensing the carrying of firearms, much as they do today. And there really aren't many states that don't allow anymore. There are only two states in the United States, Wisconsin and Illinois, that don't permit any form of carrying pretty much. And in Wisconsin, they keep enacting it. The governor there just keeps vetoing it. So it's almost down to one state. Two of the states don't have any regulations whatsoever, Vermont and Alaska, of course. And then in most of the states, I believe it's something like 8 states where it's may issue but not too permissive, and I believe the other states are all very tolerant and open. And it's interesting, we have many large American cities, living under a may issue regime, a shall issue regime, and you don't see any crime being committed by people who get the permits. A criminal is not going to get the permit. Your average gangbanger wants to sell crack, rob a post office, is not going to go to the police, and here's my NRA safety course and so on. It doesn't happen. So, thanks.
Today at the City Club, we have been listening to a special program featuring Alan Gura, partner at Gura and Pozeski. Thank you, Alan, and thank you, ladies and gentlemen. This program is now adjourned.